Welcome to a masterclass on immigration law and what rights illegal immigrants have in the United States. We're going to look at a range of cases, including the first one, or one of them, is the Shaughnessy case from 1953. We're also going to look at the Ludicky case, the Yamataya case, the Wong Wing case, the Fong Yu Ting case, and the Che Chan Ping case. So let's start with the most recent one, and that being the Shaughnessy case. So Shaughnessy versus the U.S. ex rel Metze. You can find the citation on Justia or other freely available legal websites, including and you can find the citation, as it's called, at 345 U.S. 206 from 1953. These are all cases decided by the Supreme Court of the United States. Now let's go to the basic facts, or the syllabi as it's listed in the Supreme Court's case. An alien resident of the United States traveled abroad and remained in Hungary for 19 months. So let's take apart that first part of the statement. So this is someone who was legally admitted into the United States, but was not yet a citizen. On his return to the country, the Attorney General, acting pursuant to a certain federal laws, ordered him permanently excluded without a hearing. The order was based on, quote, information of a confidential nature, and on a finding by the Attorney General that the alien's entry would be, quote, prejudicial to the public interest for security reasons. Other nations refused to accept him, so his exclusion at Ellis Island was continued for 21 months. He ultimately filed a habeas corpus proceeding. A federal district court directed that his conditional parole into the United States on bond. The case went up to the Supreme Court of the United States. What did the Supreme Court hold? The Attorney General's continued exclusion of the alien without any hearing does not amount to an unlawful detention, and courts may not temporarily admit him to the United States pending arrangement for his departure abroad. Notably, the court concluded that in exclusion cases, the court cannot retry any decision made by the Attorney General. That if the executive branch concludes an alien's entry would be prejudicial to the public interest, that's it. It is not reviewable. That decision, that action is not reviewable by a court. Neither an alien's harborage on Ellis Island nor his prior legal residence in the country transforms an administrative proceeding by the executive branch against him into anything other than an exclusion proceeding. And he may be excluded if unqualified for admission under existing immigration laws as made by the unreviewable decision of the executive branch. Although a lawfully resident alien may not be unfairly deprived of his constitutional right to due process, the alien in this case is an entrant alien or assimilated to that status for constitutional purposes, distinguishing prior cases. The Attorney General, therefore, may exclude this alien without a hearing, as authorized by the emergency regulations promulgated pursuant to the Passport Act. And he need not even disclose that evidence upon which that determination rests, not even to the alien himself and not to the courts. The alien's continued exclusion does not deprive him of any statutory or constitutional right. Why? Because the alien's right to enter the United States depends entirely on congressional will, and courts cannot substitute their judgment for Congress's judgment. So the Justice Clark delivered the opinion of the case, and throughout it you'll see very broad language about the nature of the court's lack of power to counter the executive branch's unilateral determination pursuant to congressional authorization. Indeed, let's quote from the case. This is page 345 U.S. at 206, and then specifically at page 210. Courts have long recognized the power to expel or exclude aliens as a fundamental sovereign attribute exercised by the government's political departments. Namely, that's who are the political departments in the U.S. government? The elected branches of government. Who is that? The President of the United States and Congress. And this power to expel or exclude, noted that, power to expel or exclude. This includes excluding them when they try to come in and expel them from the country when they're already here. And what about this power is, quote, a fundamental attribute of sovereignty. And who has exclusive control over that power? The government's political departments, Congress and the president. And it goes further. This power is, quote, largely immune from judicial control. Largely immune. In other words, the courts are in no business to second guess the decisions of the President of the United States when it comes to matters of immigration, especially illegal immigration, particularly those immigrants that have been identified as posing a danger to the country. In the exercise of these powers, the court continues, Congress expressly authorized the president to impose additional restrictions on aliens entering or leaving the United States during periods of just, quote, international tension and strife. That authorization continues in effect during the present emergency. When was this decision issued? 1953. When was the law passed? 1918. So even though the law was passed during World War I, and this is a case being decided in 1953, long after World War I, their point is the president gets to decide whether that emergency about international tension and strife is present, not the courts. The Attorney General acting for the president may shut out aliens whose entry would be simply prejudicial to the interest of the United States. And he may exclude him without even an administrative hearing, even when the exclusion is based on information that is not given to him or anybody. And there is no role for the courts in this context. What they have noted is that it is true that aliens who have once passed through our gates, even illegally, may be expelled only after proceedings conforming to traditional standards of fairness and encompassed in due process. And we'll get to what does that mean in the illegal immigration context. But an alien on the threshold of entry stands on different footing. Whatever the procedure authorized by Congress, it is due process as far as any alien denied entry is concerned. Let's listen to that again. The only due process an immigrant is entitled to at the border is whatever Congress has chosen to give it him and whatever the executive branch chooses to do. And, quote, because the action of the executive branch under this authority controlling immigration is, quote, final and conclusive, the government cannot even be compelled to disclose the evidence underlying the exclusion. Quote, it is not within the province of any court, unless expressly authorized by law, to review the determination of the political branches of government, namely the president and Congress. In a case such as this, courts cannot retry the determination of the executive branch on the government. Notably, they note the fact he is being detained has no bearing on it. That conceitedly, his movements are restrained by the authority of the United States, and he may by habeas test the validity of his exclusion, but that is true whether he enjoys temporary refuge or remains consciously aboard a ship. And for the purposes of immigration laws, the legal incidence of an alien's entry remains unaltered, whether he has been here once before or not. He is an entering alien just the same and may be excluded if unqualified, as determined by the executive branch. They talk about procedural due process, but they note we held that under some circumstances, temporary absence cannot constitutionally deprive a lawfully resident alien of his right to be heard. Notice that. you have to be present within the country legally in order to be entitled to due process, according to the Supreme Court in the Shaughnessy case. Now let's go to the next case. And we'll flip up here. Here we go. Boom, boom. And we, where is it? There we go. And up next, we will go to Ping and see what this case holds. This was one of the first cases concerning immigration law. And here again, a lot of these cases are determined in two separate independent contexts. The cases from the late 19th to early 20th century generally included so-called Chinese exclusion cases. There were some cases concerning Japanese citizens and German citizens during World War I and World War II. And then there were cases concerning communists during between 1940 and 1960. This was one of the earliest cases determining who gets to decide what happens to someone who is here if they are an immigrant, particularly if they are maybe here illegally or trying to enter illegally. Is there any role for the courts, or is it solely up to the so-called political departments, the elected branches of government, Congress, and the president? So here we have this case. You can find it 138 U.S. 581. That's the official court reporter that keeps an official copy of the case. You can find it throughout various online locations. And again, it's Ping versus the United States. In their relations with foreign governments and their subjects or citizens, the United States are a nation invested with powers which belong to all independent nations. So far as a treaty made by the United States with any foreign power can become the subject of judicial cognizance in the courts of this country, it is also subject to such acts as Congress may pass for its enforcement, modification, or appeal. The abrogation of a treaty operates only on future transactions, leaving unaffected those executed under it prior to the abrogation. They're talking about various rights and issues created by treaty. Of note, they say the power of the legislative department of the government to exclude aliens from the United States is an incident of sovereignty which cannot even be surrendered by the power to make treaties. This was concerning what treaties existed between the United States and China concerning citizens of China. This case comes before us on an appeal from the order of the Circuit Court of the United States for the Northern District of California, refusing to release the individual on a writ of habeas corpus from his alleged unlawful detention by Captain Walker, a master of the steamship lying within the harbor of San Francisco. The appellant is a subject of China and a laborer by occupation. He had previously resided in the United States, residing at San Francisco for multiple years before he left for China. On his return to China, or on his return to California, on his arrival, he presented to the proper customs house officers his certificate and demanded permission to land. The collector of the port refused the permit solely on the grounds that under the Act of Congress approved in 1888, 1882, and 1884, the certificate for him to land had been annulled and his right to land abrogated, and he was thereby forbidden to enter the United States. The captain therefore detained him on board the steamer. He filed a petition, a habeas corpus petition, alleging he was unlawfully restrained of his liberty and asked that a habeas writ be issued to release him into the United States. Upon the hearing which followed, the court, after finding the facts substantially as stated, held as conclusions of law that he was not entitled to enter the United States and that he had not been unlawfully restrained of his liberty because he had no right to release in the United States to begin with. The court goes through the entire history of the treaties, the history of the Chinese exclusion laws, where it comes from, how it applies in this precise context. And what it ultimately is, you go through that sort of long, detailed procedural issue, talking about where the immigration from China came from, talking about the history of the gold rush, and so on and so forth, why Congress ultimately passed the laws, and whether the treaty abrogates other principles that are in place. And after you get through all of these sort of constituent predicates to the court's conclusion, what we find are things like this. It will not be presumed that the legislative department of the government will lightly pass laws which are in conflict with the treaties of the country, but the circumstances may arise which would not only justify the government in disregarding it, but the interest of the country may require them to do so. So this was explaining why and how treaties are not self-enforcing in America and didn't change the underlying power of the government as it related to matters of immigration in particular in this instance. They note what's controlled by local issues and as opposed to what is the foreign power. The power to declare war, make treaties, suppress insurrection, repel invasion, regulate foreign commerce, secure a republican government to the states, and admit subjects of other nations to citizenship are all sovereign powers, restricted in their exercise by the Constitution itself and considerations of public policy and justice, which control more or less the conduct of all civilized nations. Talking about there's an inherent power of all nations to exclude people from its borders. Basically, this is the legal way of saying that it's only a country without borders is not a country. Goes through the history of that power always being a power that is within the right of any independent nation to give. The power of the government to exclude foreigners from the country, whenever in its judgment the public interest requires such exclusion, is recognized repeatedly. And they go through all the different times where they've repeatedly said that any government, any country, any independent nation has the right and often the obligation to exclude. As to criminals, the power of exclusion has always been exercised, even in the absence of any statute on the subject. Noting that from our very beginning of our history, we have excluded people, often unilaterally by the executive branch, even without Congress passing law on it, because it's an inherent power of the executive branch of any independent nation of the government, and the executive branch is authorized under the Constitution to do so. They talk about how these powers cannot be sacrificed or forfeited, but remain an inherent power that is not capable to that. There can be no question in this court that where a continued suspension of the exercise of governmental power is insisted upon as a right, it has not heretofore been exerted with respect to immigrants. Basically, because property rights not affected by the termination or abrogation of a treaty and expectation of benefits from the continuance of existing legislation, there is as wide a difference as between realization and hopes. They're just pointing out that when it comes to the matters of immigration, there is broad power. We do not attach the act vested in the president power to order all such aliens as he should judge dangerous to the peace and safety of the United States, or have reasonable grounds to suspect were concerned in any treasonable or secret machination against the government, to depart out of the territory of the United States within such time as should be expressed in the president's order. In other words, it is enough, however, to say that it is entirely different from the act before us, and the validity of its provisions was never brought to the test of judicial decision in the courts of the United States. Ultimately, the Supreme Court said the president has complete power, carte blanche, regardless of treaties or anything else, to exclude anyone he considers dangerous from the country. And this was a decision issued in 1889 by a unanimous Supreme Court. Now let's go to the next one. Here we go. We will go to Fong Yun Ting. Fong Yun Ting versus the United States, 149 U.S. 698, decided in 1893, again by the Supreme Court of the United States. Note, we'll start with the syllabus. The right to exclude or to expel aliens, or any class of aliens, absolutely or upon conditions, in war or in peace, is an inherent and inalienable right of every sovereign nation. In the United States, the power to exclude or to expel aliens is vested in the political departments of the national government. In other words, it is up exclusively to Congress and the president who gets in and who gets kicked out. It can be regulated by treaty or by act of Congress, but it is to be executed by the executive authority. And that there is only a role for the judicial department where Congress has authorized it. The power of Congress to expel, like the power to exclude aliens or any specified class of aliens from the country, may be exercised entirely through executive officers. It is up to Congress if they want to call in the aid of the judiciary. Congress has the right to provide a system of registration and identification and to take all proper means to carry that out, but it is the provisions of the Act of Congress, and it must be clear and explicit for the courts to get involved at all. Here again, we have another Chinese exclusion case brought in the context of someone claiming they were unlawfully withheld under the basically bringing a habeas corpus claim. And they're going through the whole history of what took place, how it took place, why it took place, and concerning these Chinese exclusion laws. And they go through and they again reiterate it's the inherent power of all courts, as the Supreme Court has repeatedly reiterated from the very inception of these adjudications of immigration, that the political branches, Congress and the president, decide who gets in and who gets out, and they do so without judicial review unless Congress specifically delegates that power in that precise context to the courts. The talks about the whole nature of, especially when this relates to foreign affairs, and immigration inherently does so, and the Constitution gives that power to the president, not to anybody else, not to the courts. The courts are not in that business. They mention how this is universal and consistent with the law of nations and the custom and practice of nations throughout the history of the world, to be able that the executive branch can unilaterally exclude people from the country, even if they're already here, if there's someone that does not have a legal right to be present within the country. And they talk about the history of, particularly as it applied to England, and why it was done here in the United States. The United States are a sovereign and independent nation and are vested by the Constitution with entire control of international relations and with all the powers necessary to maintain that control and make it effective. The only government of this country which other nations recognize or treat with is the government of the United States. And the only American flag known throughout the world is the flag of the United States. The Constitution of the United States speaks with no uncertain sound upon this subject. The Constitution established by the people of the United States as the fundamental law of the land, conferred upon the president the executive power, has made the president the commander in chief, has authorized the president to make treaties and appoint ambassadors, and has made it the duty of the president to take care that laws be faithfully executed. The Congress has granted to Congress the power to regulate commerce, the entrance of ships, the importation of goods, and bringing of persons in, the uniform rule of naturalization, and so forth. And it's from these aggregate specific delegations that Congress and the president have exclusive control, as the Constitution nowhere gives to the courts any role in immigration unless Congress has specifically chosen to involve them in that capacity, especially for those that do not have any legally vested right to be here in the United States. Remember, due process of law only requires all the process that is due, and the only process that is due is dependent on what liberty or property interest you have. It's your property and your liberty that the government cannot take away without due process of law. Illegal immigrants have no property right to be here in the United States. Illegal immigrants have no liberty interest to be present in the United States when they are here illegally. As long ago said by Chief Justice Marshall, the sound construction of the Constitution must allow to the national legislature that discretion with respect to the means by which the power it confers are to be carried into execution, which will enable that body to perform the high duties assigned to it in the most beneficial manner, which are appropriate and plainly adopted to those ends. Namely, the Constitution gives to Congress the decision about immigration rules and to the president the enforcement of those rules unless Congress chooses and specifically decides otherwise. The power to exclude or to expel aliens, being a power affecting international relations, is vested in the political departments of the government, Congress and the president, because those are the only ones elected, and can be regulated in these other ways according to how Congress and the president so choose. But there's no role for the judicial branch to intervene unless explicitly given that power by either the Congress or the president. As he noted, they say Congress might authorize the courts to investigate and ascertain the facts upon which the alien's right to land was made by the statutes to depend. Yet Congress might entrust that final determination of those facts to an executive officer instead. And if it did so, the executive officer's order is due process of law. And, quote, no other tribunal, including any judge, unless expressly authorized by Congress or the president to do so, is even at liberty to re-examine the evidence on which the president acted or to controvert the sufficiency of the president's action. The power to exclude aliens, the power to expel them, rest upon one foundation, derived from one source, supported by the same reasons, and are in truth part of one and the same power. And that is the power of Congress to set the rules and the president to execute those rules. And they can be, quote, exercised entirely through executive officers. It is only if Congress calls in the aid of the judiciary that the judiciary can intervene ever. It is no new thing for the lawmaking power to submit the decision of questions either to the final determination of executive officers or the determination of such officers in the first instance. And they can decide if any judicial review is even going to be allowed. So unless Congress specifically gives it or the president expressly allows it, there is no role for the judicial review on matters of immigration, especially of those who have no legal entitlement to be present in the country. Now let's go to the next case. And here again, we'll share the screen. And we'll go to Wong Wing versus the United States. This is Wong Wing versus the United States, 163 U.S. 228, 1896. That's the year the Supreme Court decided the decision. It is once again part of the Chinese Exclusion Act cases. And they emphasize the United States can forbid aliens from coming within their borders and expel them from their territory, and can give that power entirely to executive office officials. And it is only if Congress chooses to give a judicial role is there a judicial role. And the only thing they clarify in this context is that due process of law is completely sufficient by what Congress affords and the president gives, unless you're actually seeking to imprison them, to impose punishment on them. They point out in this decision that deportation is not punishment because you have no liberty interest to be a place you had no legal right to be in the first place. By contrast, if you're trying to put someone to hard labor, if you're trying to put someone in lockup, if you're trying to impose a criminal fine, then you have to afford the same due process afforded any other criminal defendant. But it is only a criminal defendant that gets that due process, not someone being deported. Next case up we're going to cover is Yamataya. Go again, share the screen. This is a Japanese immigrant case from 1903. Yamataya versus Fisher, again by the Supreme Court, 189 U.S. 86, decided in 1903 by the Supreme Court. And again, it involves the interaction of a treaty, an administrative officer, Congress, and the courts. They note, quote, it has been firmly established by numerous decisions of the Supreme Court that it is within the constitutional power of Congress to exclude aliens, including, by the way, simply based on their race, to limit the terms and conditions upon which certain classes may come to the country. That it's up to Congress to decide the rules and regulations. And it is up to Congress to decide who gets to enforce those. And note, Congress can constitutionally commit the enforcement of immigration laws to executive officers only without any judicial intervention. An administrative officer when executing the provisions of an immigration statute involving the liberty of persons, may not disregard due process, but it is up to them to afford that due process. Where the alien had notice, although not a formal one, the courts cannot interfere with the executive officer conducting it. The objections of the alien to the form of investigation have to be made to the executive officer and to the executive agency, and is, quote, the action of executive officers in the context of immigration is not subject to judicial review. Now, last but not least, we will go to one of the more recent cases on the topic, and that is Ludicky versus Watkins. This is 335 U.S. 160, decided by the Supreme Court in 1948. Under the authority of the Alien Enemy Act of 1798. Now, note this. The Alien Enemy Act of 1798 is being invoked when? When there's no war present. This is 1948. It empowers the president whenever there is, quote, a declared war between the United States and any foreign country, and I'll explain later that can be even broader than what constitutes that, to provide for the removal of alien enemies from the United States. The president directed at the end of the war, after the war was over, the removal of all alien enemies deemed by the Attorney General to merely be dangerous to the public safety. In 1946, after the war was over, a German national was removed from the United States. He challenged the order. He instituted habeas corpus proceedings. And what did the Supreme Court say? The Alien Enemy Act precludes judicial review of his order of removal. Precludes it. Precludes it. Notably, they quote, there exists a declared war, even though there's a cessation of actual hostilities and no actual war being present. The Alien Enemy Act, construed as permitting resort to the courts only to challenge its validity and construction, does not violate the Bill of Rights or the federal Constitution. So they said it's absolutely fine. It's all the due process that is needed is whatever due process Congress gives in the law and the executive branch chooses to give the individual. The fact that hearings are utilized to secure an informed basis for the summary power. Notice summary. What's summary? It's very quick. That's it. Does not empower the courts to retry such hearings, nor does it make the withholding of such power from the courts a denial of due process. In other words, due process in the immigration context under Alien Enemies Act requires nothing more than what Congress gave and the president afforded. The courts have no role in it. And due process does not require the courts have any role in it. So once again, they affirmed and approved the removal by the president of his own non-reviewable decision that the person was subject to removal based on the rules established by Congress. Justice Frankfurter said there was no role for anybody for the court system beyond that which was already afforded under the congressional law. The Alien Enemy Act has remained virtually unchanged since 1798. Executive interpretation decisions of lower courts have found the act an authority for the president. And they say that it's now being questioned, but there is no such right to question it. Congress could give him that power. He gets to choose how to exercise that power, and there's no role for the courts to second guess that power. The power with which Congress vested the president had to be executed by him, even if executed through others. The finding at the president's behalf was likewise not to be subjected to the scrutiny of the courts. In other words, if he decides the person is dangerous, that's the end of it. If he decides the person is an alien enemy, that's the end of it. If he gives them whatever hearing he chooses to give them and Congress gave it to them, that's the end of it. That's the rule. It is up to Congress to determine what process is due someone who is illegally here, and it is up to the president to afford whatever process he believes that person is due. There is no role for the courts in these cases of illegal immigrants, and the only due process they're entitled is the process Congress affords and the president provides. There is no further due process for the courts to be involved at all when someone is not even legally present in the country to begin with. That is the undisturbed Supreme Court interpretation of the law and the vast mass of legal scholars for more than a century and a half in America. Don't like it? Change the Constitution. because that's what the Constitution compels. Thanks, everybody. That wraps up this masterclass on immigration.